Good afternoon and welcome everyone to the first of this year's Cutting Edge series of AFSA webinars. Today's discussion is presented by Debevoise Plimpton and is titled The Ethical Conundrum in International Arbitration. Debevoise Plimpton are a premier international law firm with a global practice. The firm is a founding member of AFSA, and we are delighted that they should have taken the initiative to host a discussion which has very real implications for us as we take steps to harmonize arbitral practice in the SADC region. Our moderator today is Shreya Aren of the firm's International Disputes Group, and the panel consists of Patrick Taylor, the co-chair of the firm's Africa Practice Group, and Dr. Conway, an international counsel. Thank you, Shreya. I hand over to you.
Thank you very much, Michael. I'm going to just try and share my screen. So we've got some slides and hopefully that's visible to everyone. So good morning, good afternoon, everyone. Thank you to the Arbitration Foundation of Southern Africa for organizing this webinar. We're delighted to be here today to speak about ethics and international arbitration. My colleagues Patrick Taylor and Conway Blake and I will look at risks and opportunities arising from divergences in ethical standards applicable to arbitration practitioners from different jurisdictions, and we will discuss ways for lawyers to effectively manage ethical issues. Here's a short roadmap of what we will discuss today. I will give a brief introduction to the topic and set the scene for what's to come. Patrick will then touch upon a number of major ethical challenges in the practice of international arbitration by reference to case studies which illustrate situations where this divergence can occur. Conway will look at emerging ethical and procedural challenges in the present era of virtual arbitral hearings that have become increasingly common since the beginning of the COVID-19 pandemic, and will propose some practical tips on how to handle these. We will have some time at the end for Q&A. So let's talk about legal culture and ethics. Before delving into the meat of our presentation today, I will say a few words about where these ethical dilemmas stem from. Globalization has led to an era of greater cultural diversity in legal practices generally, but especially in international commercial arbitration. This is an overwhelmingly good thing, as cultural diversity reflects a spirit of inclusivity which characterizes arbitration. Cultural diversity is desirable and inevitable consequence of arbitration success as a global means of international dispute resolution. Therefore, cultural diversity is something that we as an arbitration community should be extremely proud of. However, if the influence of cultural diversity is not anticipated by participants in the arbitral process, it can lead to difficulties. Participants could unintentionally misinterpret or misunderstand actions or omissions by parties, counsel or arbitrators on the basis of what they understand from their national jurisdictions. Or they could go into the arbitral process with a completely different expectation and understanding of what actually ends up happening. These negative aspects of cultural diversity can be damaging for the legitimacy of the arbitral process and basically lead to undermining credibility and confidence in the process. For instance, and there's a couple of examples on the slide for this, the divergence between common law and civil law, or what are technically sometimes referred to as adversarial and inquisitorial systems, can influence the participants' procedural instincts. So in common law jurisdictions, the system tends to be adversarial, which means that parties counsel advocate their client's case. While they have an overriding duty to the court, they tend to argue largely for their clients. And they ensure that the court has all the facts and the legal points that it needs to apply the law correctly. By contrast, the civil law tradition tends to follow the inquisitorial approach, which presumes that the adjudicator knows the law. She's tasked with investigating the case and applying the relevant factual and legal metrics with the assistance of the parties and the counsel. And this divergence between common law and civil law can affect a number of things. So for example, it can affect the style of submissions. In common law traditions, they're brief pleadings, often without reference to any factual evidence as well as legal arguments. The details and evidence are provided subsequently and tied together with the submission in the skeleton arguments and at the oral evidence at the hearing. In contrast, civil law traditions have lengthy submissions with reference to legal and factual information and exhibits. These are referred to as memorial style submissions, and they dominate the current arbitral landscape. The divergence between common law and civil law can also impact what parties consider is a reasonable opportunity to present their case. It is likely to be understood differently in the context of what their national jurisdictions provide for. What might be due process for the common lawyer in the context of document disclosure might be unduly burdensome and costly in the eyes of a civil lawyer. These differences can also impact a party's professional ethical standards, as these are closely connected to the legal procedure and culture in their national jurisdiction. Ethical rules will only evolve to regulate conduct that actually occurs in a jurisdiction. So for example, if there is no document disclosure in a jurisdiction, there will be no ethical rules to regulate that. Parties then import these ethical standards into the conduct of the arbitral process. Patrick will illustrate how this ends up in practice with reference to a number of case studies. On this slide, I've also mentioned an article that Patrick and I wrote with one of our colleagues on culture and ethics, where we delved into these issues in further detail. So, what do parties expect? Unsurprisingly, parties' expectations of an arbitral process can vary depending on their own legal culture. Although we are now seeing an international arbitration culture appear, our expectations of the arbitral process are still to quite an extent rooted in what we expect in our national jurisdictions. So what can be the basis of a party's expectations out of an arbitral process? What are the expectations of a party in an arbitration which is seated in London, where one party is a US party represented by US counsel, the other party is a South African party represented by South African counsel, and the arbitrator is based in Australia? We can refer to a number of objective factors which can inform the party's expectations. For example, the law of the seat of the arbitration, the governing law of the contract, and a number of the other factors which are set out on the slide. But these may not always point to the same answer. For these and many other reasons, initiatives aimed at harmonizing and standardizing arbitration practices across jurisdictions are particularly important. The IBA rules on evidence, for example, are now almost universally accepted as a starting point for arbitral procedure in international commercial arbitration proceedings, sometimes even where parties have not expressly agreed to apply them. One very pertinent initiative in this regard, given our audience, is one that AFSA is currently leading. AFSA, alongside the SADC Lawyers Association, has been working on developing a set of international rules applicable to international commercial and investment disputes arising in the South African development community. Given the combination of English, Portuguese, French, German, and Dutch influences, the jurisprudence, ethics, and procedure currently in these 16 countries is very varied. The initiative is directed at coordinating a shared arbitration profile and rules for the bloc. We look forward to hearing and reading more about this initiative. I will now invite Patrick to speak about the effect of ethical divergence on arbitral proceedings in practice by referring to case studies. Oh, Patrick, you'll have to unmute yourself, sorry.
2 years and I'm still yet to completely grasp the inner workings of the unmute button, but thank you. Well, thank you, Shreya, very much for that great introduction to this very important topic. And thank you also to AFSA for giving us this opportunity to present today. It's wonderful to be part of the development story of AFSA, and we very much look forward to continuing our collaboration and work with AFSA in the months and years ahead. As Shreya was discussing, counsel often come to international arbitration influenced by their different national systems, the different national systems that they're accustomed to and that they've grown up in. And the rules in their different national systems inform their conduct in international arbitration. It gives you your reflexes and your instincts for international arbitration. that can result in ethical divergence between different actors in arbitration, be they arbitrators, parties, or counsel. And that asymmetry of ethical standards and ethical expectations can be exploited by a party or counsel, or it can create risks. So it's really important to be aware of these divergences, where they can arise, and the potential impact that these divergences can have on your arbitrations. That will enable you, either as an arbitrator or as counsel, to try and make sure that you're creating a level playing field and operating in a level playing field. That's a mitigation of the risk that's created by ethical divergences. Or if there is not a level playing field, then ensuring that you're putting yourself in a position to take maximum advantage of an ethical divergence for the benefit of your client in seeking out small procedural benefits that might exist. If you're looking to level the playing field, and this might be something that you're particularly focused on as an arbitrator or as counsel that thinks that you might be at some disadvantage compared to your opposition, the obvious place to do that in any arbitration is through the tribunal's procedural order number 1. That assumes, of course, that the rules themselves, the rules of the arbitration that you're operating under, do not impose upon you a common set of standards, but it's our experience that they very rarely do. And so you should be thinking about these issues and thinking about whether or not anything needs to be included in procedural order number 1 in order to level the playing field. If these ethical divergences and disparities are not addressed, then the parties may engage in what we refer to as ethical arbitrage. Now, generally, it's better, we say, to try and get rid of the risk and create a level playing field, but that's not always possible. And in practice, certainly, it does not always happen. So I'm going to turn to considering now certain examples of how ethical divergence impacts arbitral procedure in practice. If we could turn to the next slide, please, Shreya. So the first issue is document production and disclosure. And if I could just give you all 10 seconds to read the situation, the set of circumstances that we put on the slide, I'll then walk through some of the considerations that arise. So there's general agreement that some ability to request document disclosure in international arbitration is valuable, although that concept has been coming in for quite a lot of criticism over recent years. And I think it's partly because of what we're about to describe. The question of what obligations could bind different parties and counsel when it comes to document disclosure, and whether or not those are the same for all counsel, is something that creates a risk of an unbalanced playing field on this particular subject. In both the UK and the US, the failure to produce documents that undermine the producing party's case, or that are in some way contrary to the producing party's interests, where those documents have been ordered for production by the tribunal, constitutes severe misconduct by the counsel representing that party. That approach contrasts sharply with the general approach to discovery in many civil law jurisdictions. In some of those jurisdictions, disclosure of documents harmful to a client's case may in fact put counsel in breach of their professional conduct rules and obligations to their client. And so you can see how two different counsel might have very different obligations in relation to the disclosure of documents. In international arbitration, a strong consensus emerged on a common standard for document production under the IBA rules on the taking of evidence, which Shreya referred to earlier. And those are broadly speaking based around a common law approach to document disclosure. Dissatisfaction with that common law approach by some more civil law minded practitioners led to the emergence of the Prague rules, which takes a more civil law approach to the issue of document disclosure. And both are available. And when you go into an arbitration, it'd be important to consider whether either of those would be an appropriate set of standards or guidelines for you to adopt in order to ensure that both sides are operating on the basis of the same disclosure and evidence rules. The relatively more common law focused IBA rules work only because of the strict duty on counsel to turn over all responsive documents, whether helpful or damaging to their client's case. But in jurisdictions where you either don't have document disclosure or the approach to document disclosure is very different, there are no ethical obligations obliging a counsel to turn over those particular documents. And that can be very problematic. It may lead to distrust between counsel on different sides, or dissatisfaction by a party that perceives that the other side is not complying with its duty to disclose documents. It could even lead some parties to decide at the outset of a matter where they may know that they have documents that are harmful to their case, to decide not to hire counsel from jurisdictions that have ethical obligations on disclosure in order to ensure that they won't be put under pressure to disclose documents that would be unhelpful to their case. And I have heard that mentioned by a number of people in the sector, that they have had experience of conversations with clients along the lines of, if you've got an obligation to disclose, why shouldn't I sack you and hire a lawyer that doesn't have an obligation to disclose? It does come up as a real problem in real life. The penalty in arbitration for the failure to produce all documents ordered to be produced is usually the drawing of adverse inferences. In other words, the ability for a tribunal to say, we ordered you to produce a document that we believe exists, you've not produced that document, therefore we will assume that it exists and that it was adverse to the interests of your client. The deterrent effect of adverse inferences is certainly less of a deterrent effect than personal sanctions against a lawyer that is bound by an ethical obligation to produce all documents, even those detrimental to their client's case. And the other thing with adverse inferences is that in practice, they can actually be very hard to trigger in an effective way, because it's one thing to say that the document may have been harmful to the interests of your client's case. It's quite another thing to work out exactly in what way they might have been harmful to your client's interests and what the impact of that harm would be on the overall presentation of your client's case. So that's the first subject area that we were going to focus on. And if we could turn to the next slide, I'm now going to invite you to read briefly this next set of circumstances, and I'll talk to those in a couple of seconds. So here we're dealing with without prejudice communications between counsel, including what we refer to as without prejudice save as to costs communications, which is a species of without prejudice communication. The issue is whether or not the jurisdictions from which the counsel come, or the jurisdiction in which your arbitration is taking place, recognizes the concept of without prejudice communications. And if they do, the question also arises whether or not all counsel will feel bound by the confidentiality that such a rule imposes. Now, this issue is in fact regularly, in my experience, an issue that causes conflict between opposing counsel from different jurisdictions. Certainly in a great number of cases over the last 5 years of my practice, I have come up against issues where counsel on different sides have had different views as to whether or not the communications between them are privileged or confidential, whether they can be referred to in front of a tribunal, or whether any settlement offers could be referred to in front of a tribunal. And this, you won't be surprised to hear, can lead to immense dissatisfaction by parties on how the arbitration dealt with the specific issue. Now, in common law jurisdictions, generally speaking, the concept of without prejudice privilege is recognized. And as you'll know, many of you will know certainly, without prejudice privilege is a privilege that attaches to correspondence that is made in a genuine attempt to reach a settlement of your dispute. If a party makes admissions in such correspondence, the other party cannot use those admissions in any of the ongoing proceedings to harm the other side's case. Without prejudice correspondence, generally speaking, can only be waived with the other party's consent or in certain exceptional circumstances. Now, as I mentioned, a variant of the without prejudice privilege is without prejudice save as to costs. And this is in England also referred to as a Calderbank offer. Now, these can be provided to courts or tribunals as a basis to factor in on their costs decisions. And the way it works is you make a settlement offer. If that offer is rejected, and even, well, if it was accepted, obviously it would lead to the end of the arbitration. But if it's rejected, the offer cannot be referred to in front of the tribunal or the court until such time as the merits of the case have been determined. Once the merits of the case have been determined, then the offer can be revealed to the court to take into account for its cost decision. And if the party that won the arbitration, but not as successfully as it would have done if it had accepted the offer, or in an amount, for example, that was similar to the amount that was offered as part of the settlement offer, then the court or tribunal can take that into account in determining whether or not the losing party should bear the costs for the period after that settlement offer was made. In common law jurisdictions such as South Africa, Australia, the UK, Hong Kong, New Zealand, Nigeria, this principle is recognised. And it's important to note that in the English rules on privilege, if your arbitration is seated in England, then you will be bound by the rules on without prejudice service to cross communications, even if you as a counsel come from another jurisdiction. But in a number of civil law jurisdictions, such as Austria, Brazil, China, and Russia, the concept of confidentiality associated with without prejudice correspondence is not recognised. Other civil law jurisdictions do recognise without prejudice correspondence in limited circumstances. In Belgium, Spain, and France, correspondence between counsel is always confidential unless it's specifically identified as not being confidential. But what they don't have is a concept of being a communication being confidential only to up to a certain point in the proceedings. So what are your options in those jurisdictions? Well, usually your only option is to write to counsel from the other side, seeking to agree almost on a contractual basis how you will extend an offer and how the confidentiality of that offer will be treated prior to actually making the offer. The problem is that if you want to make a without prejudice service to cost offer, it's usually to gain a strategic and tactical advantage. And in my experience, a switched on opposing counsel will refuse to accept the communication on that basis in order specifically to avoid the risk of finding themselves hung up on their own petard in front of the tribunal at a later point when it comes to the decision on costs.
Patrick, just to ask you a question here, you mentioned that the letter remains confidential, and I understand that that's the case in certain jurisdictions. But in situations where it can contain statements that are detrimental to the other side's case, is that something that I can use to develop my client's case, not using the letter itself, but just what they've said in the letter? Or would that also be against my ethical conduct?
Well, obviously, that may depend from jurisdiction to jurisdiction. And in the English context, you would have to be very careful not to refer to the contents of the admission that was made. But of course, when you design a without prejudice communication, you have to be careful also not to include information that exactly could be used in the way that you suggest, so that without any reference to the admission, your other side changes its case in a way designed to exploit the admission that was made, either by exploiting a weakness in your case that they hadn't thought of, or some other advantage to them from what you've said. And so you need to be careful about what you include in your communications, even if they are without prejudice.
Understood.
So moving then to the next slide and the third topic, the third area where we see ethical arbitrage, still on the theme of privilege and confidentiality, the question arises whether or not counsel have an obligation to return privileged information that may have been disclosed by mistake. And I'll invite you all in the next few seconds to read the set of circumstances on this slide. So in most common law jurisdictions, including South Africa, Australia, Hong Kong, New Zealand, and in some civil law jurisdictions, such as Belgium and the Netherlands, the rules will compel counsel to return privileged information which was disclosed by accident. In Australia, even if a client instructs a solicitor to read the confidential material received in error, the solicitor must refuse to do so. In some jurisdictions, there's no obligation to return the privileged information though. but there may be broader ethical principles that would encourage you to do so. In Nigeria, the general obligation of good faith and the prohibition against taking undue advantage of opposing counsel or their client would likely imply an obligation to return privileged information. In Austria, there is no specific obligation, but the attorney has a duty to act in line with a duty to uphold the profession's reputation and honour. And in France, they take a slightly different approach, quite an interesting one. Receiving counsel can be subject to criminal and disciplinary actions for using mistakenly disclosed documents. And that's because they would be breaching attorney-client privilege, even though that attorney-client privilege is an attorney-client privilege between their opposing counsel and their opposing counsel's client. In other jurisdictions, such as Brazil and China, there is no obligation at all to return the privileged documents, and the opposing counsel's privilege rules are not relevant, and so that material can be used by opposing counsel. So you need to think very carefully about who your opposing counsel are, and if they are from a jurisdiction that has no obligation to return such material, you're going to want to be extra cautious when filling in the autocomplete bar on your emails to make sure that you're not accidentally divulging information to the other side. The International Bar Association has identified this and just now in January released a statement that is aimed to defend the principle of lawyer-client confidentiality, which takes note of the differences across jurisdictions and argues the importance of the client-lawyer confidentiality concept in international arbitration as an important aspect of the administration of justice and the rule of law. So it's a clear sign that these issues are being targeted for harmonization, and that is a good thing because obviously it can be very unfair just by virtue of where your opposing counsel comes from. You could be significantly prejudiced by the disclosure, unwitting disclosure of a privileged communication. So turning then to the next issue, which is dishonesty and fraud allegations. If you could turn to the next slide. Thank you, Shreya. So I'll give you a few seconds again to read the set of circumstances on this slide. Now, most jurisdictions have rules prohibiting the making of frivolous claims or allegations. In the majority of cases, therefore, it's improper for counsel to advance allegations or make applications for the sole purpose of harassing a party or undermining the efficient conduct of the proceedings, sometimes referred to as a form of guerrilla tactics in arbitration. But there is a significant divergence between the penalties available to sanctioned parties and counsel that breach such rules in different jurisdictions. At one end of the spectrum, in certain jurisdictions, it's possible to bring an action against a party or its counsel for malicious prosecution of civil claims. In others, there's no sanction at all. Frivolous allegations as a form of guerrilla tactics undermines the legitimacy and effectiveness of arbitration, and stronger powers to sanction such behavior, such as powers confirmed by the IBA guidelines on party representation, where they're adopted, would help to address this. But the IBA can't fix this all by itself. National systems need to come together to ensure that there's a level playing field on these sorts of issues. If my own experience over the last few years is anything to go by, there is a trend, an increasing, a broader trend now of counsel accusing opposing counsel of having engaged in unethical conduct or fraudulent behavior. And that invariably results in increased costs in the proceedings. I assume that counsel use these tactics because they consider that sort of all is fair in love and war, but it does nothing for the reputation of arbitration. As I said, it increased costs because every time one of these allegations is raised, you have to take time to address the allegation and show why it was not justified. But if there's no sanction for making the allegation in the first place, then parties may feel there's very little downside to seeking to cast aspersions on the bona fides of the opposition. In England, it's a breach of a counsel's ethical obligations to allege dishonesty in the absence of cogent evidence. And as a result, such allegations rarely feature in English court proceedings. But regrettably, we are seeing them more and more in arbitration proceedings. I believe that the rule also exists in South Africa, and that is a good thing too. But all national rules should be equally stringent. And until they are, we may want to think about whether or not we need a global standard through an IBA rule or something similar in order to ensure that counsel treat each other with respect in international arbitration in order to maintain a lid on costs. I've got a nice story one of my partners told me about a case that Debevoise did against Freshfields a couple of decades ago, where the case was over very quickly, very efficiently, and counsel on both sides have a very strong recollection of the respect with which the sides treated each other and their ability to communicate effectively in order to agree a very efficient procedure and in order to basically get to an outcome in the case with the minimum amount of cost expended. It left a very strong impression on both sides, and certainly it's something that we try to do in our matters, to act in a way that treats all sides with respect in order to keep a lid on costs.
Patrick, just one question here. I mean, you mentioned that there are a number of jurisdictions where ethical standards prohibit counsel from actually making these allegations, but you also mentioned that there is a trend, and I think all of us who are involved with international arbitration will remember receiving very aggressive correspondence alleging all kinds of misconduct. So why do you think that is? Is this just one of those areas where what should happen just is different from what happens in practice?
Look, I think, aggressive correspondence is a feature even in court actions in England where the rule exists. It's about where to draw the line. It's one thing to be aggressive, to fight your case very hard, to make sure that the other side is complying with the ethical obligations that it has, where there's any risk that it's not, and to keep everyone honest. But it's quite another thing to allege dishonesty or some form of fraudulent activity in circumstances where you know that there is zero evidence of that being the case. And I think knowing where to draw the line is the important thing there.
Thank you.
So turning then to the final sort of case study that I want to present, it's probably the most famous one, and it's to do with witness preparation. I'll give you a couple of seconds just to read the case study. So in the United States, a failure to prepare a witness to the fullest allowable degree prior to them giving oral evidence may constitute ethical misconduct or malpractice by a US lawyer. While US attorneys can therefore conduct several mock cross-examinations on the evidence as a means of preparing a witness, solicitors and barristers presenting cases in court in England may not do so. By further contrast, some European lawyers are prohibited altogether from pre-testimonial communications with witnesses and could even be subject to criminal sanctions for non-compliance. The IBA rules on evidence that Shreya referred to earlier and I referred to earlier, and the IBA guidelines on party representation are helpful in setting out what the international arbitration community deems to be acceptable practice for the preparation of witnesses in international arbitration. But the problem is, if your national ethical rules are more restrictive than the IBA rules, then you may be bound by those rules, even if you're operating in an arbitration, and even if that arbitration arguably is seated outside of your home jurisdiction. So we need national bar associations to be alive to this in order to help us create a level playing field. Until they do, the kind of situation that sort of is explored on the slide here will continue to exist. Interestingly, in some national systems, I think France is one of these, they've identified the risk. And what they've done is they've got a very restrictive rule for domestic court litigation. But where a French lawyer is engaged in international arbitration, they are subject to a more permissive rule that essentially equates to the standards set out in the IBA rules. Until that happens for all of us, we're going to be stuck in the situation where most of us will want to have at least one US lawyer on our team in order to ensure that witnesses can be prepared in a way that is acceptable according to the IBA rule standards. So if we turn to the next slide, I wanted to leave you with two thoughts. The first is this, which is we've gone through some case studies dealing with some of the issues where you see ethical divergence. But what you see on the slide here are a number of other areas where we are aware of potential for ethical arbitrage and divergences in ethical standards. And if you have any questions about any of these, we'd be very happy to take them at the end. Equally, I think we've got our email addresses at the end, and if you wanted to discuss any of these offline, we would be very happy to do so. And the final point I wanted to leave you is really a question. Given the risks attaching to such ethical divergences, is it time that we look to move towards a standardized ethical code when it comes to arbitration? The idea has always actually received a mixed reaction, but undoubtedly it would address some of the challenges in this area and go some way to creating a level playing field for arbitration lawyers. It does require buy-in from national bar associations and the acceptance that some of the solutions may result in a divergence from the domestic set of rules. The other downside, of course, is that one of the benefits or one of the achievements of arbitration is really the way it's been able to attract people from all sorts of different legal backgrounds and to sort of reach a really supranational state. And too much harmonization can ultimately limit the scope for improvement of procedures and limit the scope for arbitration to continue to develop and improve itself, thanks to the different points of view that are brought to the arbitration playing field. So not a straightforward question, but one that no doubt lots of people will continue to think about. And with that, I'll hand you back to Shreya.
Thank you very much, Patrick. In the last part of our session today, Conway will talk about virtual hearings. As Patrick mentioned, we'll be taking questions at the end. So if you have any, please do pop them in the chat or the Q&A on Zoom, and we can take a look at those towards the end. Conway, I know that you, over the course of the last couple of years, have done a number of virtual hearings. So I think you've now seen everything there is to see about them. So please tell us everything we need to know about overcoming challenges in virtual hearings.
Thank you very much, Shreya, and welcome everyone. It's a real honor and privilege to be sharing with you on this webinar. So as Shreya said, we have in the last 2 years come out of a period in which we were thrust into a lot of chaos. We were all wondering what would happen in the midst of isolation, lockdowns, about whether arbitration would survive and whether hearings would have to stall. And while in the immediate aftermath of the beginnings of the pandemic, we thought that it wouldn't be life as usual. What has been one of the striking features of legal practice has been the way in which arbitration has just embraced technology and moved forward, and the way in which lawyers, who are often seen as Luddites, have been able to use the various electronic platforms and conferencing platforms to bring arbitrations to completion. And so that's a very, very remarkable development. But we don't think that the move to virtual hearings will be something that is a relic of the pandemic era when it comes to an end. We definitely have a sense that virtual hearings will be a feature of arbitration. Perhaps all hearings will not move virtually. We're seeing a lot of people going back to in person, but we definitely think that virtual hearings will be a part of arbitrations, particularly procedural hearings. But it may be an option that people will seek to pursue in larger cases where there are multiple individuals in different jurisdictions, where people are cost conscious. There are lots of opportunities that arise for litigating and having arbitration by virtual platforms, but there are also risks and things that we need to be aware of. And so what we want to talk about today are the risk and the issues which arise, both ethical risk and issues, but also procedural risk and issues. And because we're talking about the ethical dimensions of virtual hearings for the most part, I want to highlight two ethical issues that are implicated, most directly implicated in the context of virtual hearings. And then I'm going to turn to the procedural challenges which arise from virtual hearings and some of the things we can do practically to mitigate the risks and to meet the challenges and to maximize the opportunities presented by virtual hearings. So the first ethical duty, I think, is implicated by virtual hearings is the duty of competence. This is a duty that is enshrined in the IBA rules on ethical conduct in arbitration, Rule 2.2, but it's also a rule that I think is codified in most systems and most codes of conducts for lawyers in legal systems throughout the world. And it is basically this, that lawyers and arbitrators should not accept mandates for which they're not prepared and they're not competent. And an arbitrator should not accept any arbitral appointment if they don't feel able to meet the challenges and to handle the issues that are there, that are presented by that case. Now, we tend to think of the duty of competence as only engaging the substantive issues. Am I a construction lawyer? Am I a tax lawyer? But actually, increasingly, and particularly in the context of virtual hearings, there have been discussions about whether we should be asking whether arbitrators are competent with technology, whether they understand the technology, they can properly conduct hearings, particularly large and complex hearings with a lot of documents in the context of the virtual world. Because we will all have seen during the pandemic, a number of us struggling with technology, a number of hiccups, some people being far more savvy than others. So the point here is simply, we as counsel should be ensuring that we're upskilling to make sure that we can develop the skills to properly serve clients, and that arbitrators should also be doing the same because it implicates a fundamental duty of competence. The second duty that I think is implicated is the duty of confidentiality. We all know this duty of confidentiality, but we think that it's clear that this duty is heightened, or it's particularly in play in the context of virtual hearings because of the systems of document retention and document transfer and data protection issues that are in play. Increasingly in the virtual world, we have repositories of documents that need to be uploaded, and people having to deal with passwords and different systems for storing documents. And I've personally seen lots of mistakes being made by counsel in disclosing documents to the other side mistakenly that shouldn't have been disclosed, and the perils of not having a system within your firm or within your practice that is safe, or understanding that system. There are also the ethical issues of what you do if you receive a document by error, whether by email or whether it's put on the file sharing site of the arbitration, and what you do in those circumstances. But the point I want to underscore here again is to be aware of our ethical duties in that context, in the procedural context, in the operational context of the arbitration. And these nuts and bolts issues, these technical procedural issues, are very important because they can go to the integrity of the award. You can have an arbitration, a successful virtual arbitration, have some hiccups, and you think, well, it was really a struggle for that arbitration, but in the end I won. But the problem is, after winning, that's not the end of it, because if those technical hiccups, those procedural issues in any way impugn the integrity of the proceedings, it may very well form the basis of a set aside, and you may have your award challenged and set aside because we did not pay sufficient attention to the technical aspects and the procedural and ethical dimensions of the virtual hearing. So if we move to the next slide, please, Shreya. So on the slide, what you have here is the well-known Article 5.1 of the New York Convention. And as you can see there, it talks about when a court can refuse to enforce an award. And you can see two really big planks for non-enforcement. One of the parties, where one of the parties is unable to present his or her case. That's a big issue, a question of fairness, which goes to the integrity and the enforceability of the award, or where the arbitral procedure was not in accordance with the agreement of the party. So the integrity of the arbitration proceedings really stem from the fairness of the proceedings. And if, by virtue of the way the oral hearing, the virtual hearing was conducted, that duty of fairness, that principle of fairness has not been upheld, it may be that the award is liable to be set aside. So I want to talk about some of the issues that can arise in the context of a virtual hearing that may cause issues for enforcement and some potential solutions to prevent or handle these issues. But before going into any detail, I want to say to you that our biggest recommendation is to be proactive about virtual hearings and setting them up. You may think that a virtual hearing is much more easy to set up than an in-person hearing. You're not traveling, you're not having to set up physical rooms, but actually I found them more demanding because by and large, because of great institutions like AFSA, physical hearings, we know what the rule book is. The institution set up the room, we know where the bundles go, we understand. But in the virtual space, there's much more pressure and duty on the lawyers to think through the technicalities of the hearing and what may go wrong. So being proactive is very important. Thinking about hearing protocols, the rules that will govern how the arbitration is playing out, and speaking proactively with the other side and with the tribunal and agreeing on the procedural orders in relation to the hearing and the hearing setup way in advance. So what are some of the issues that can come up and that you should be thinking about as you develop your protocol and speak to the other side and to the tribunal on issues of virtual hearings? If you move to the next slide, Shreya. One of the area of concern, an ethical area, an issue about integrity, is to do with witness testimony. It's tricky in-person hearings, witness testimony, but in the virtual environment, it's even much more difficult. They're important issues for both the tribunal and for counsel, because one of the cornerstones of cross-examination and why we have cross-examination is the idea that we ought to be able to put evidence and put issues to the witness, and for the tribunal to see the witnesses' testimony, hear what they have to say, and to have an assessment of whether they think that the evidence is given is from a witness of truth. But one of the things that people have been speaking about is the fact that in virtual hearings, that is attenuated. You're seeing someone from a screen, and it's very difficult, or much more difficult, to assess body language and to assess the truthfulness of a witness. And there are various aspects to that. But actually, I want to share one experience I had just yesterday from a hearing where witnesses were giving evidence from Port Harcourt. And just the issue of lighting was an important issue, because while the evidence was being given by video and the connection was good, the room was very dark. And actually, you couldn't see the faces of the witnesses very clearly. So while we could hear them, you could see the raised eyebrow and the shrug as much. And that had actually some implications for whether you thought you should push a question further, or whether the tribunal could have an assessment, make an assessment of whether that witness was a witness of truth. So, things like lighting may not be the things that we think about as lawyers, but they may be important for how witness evidence come across and how you're able to test evidence and to know whether your cross-examination is going well. And you have to think about the fact that in a virtual environment, the tribunal and counsel will be looking at various screens. There'll be lots of things going on. They might have a private chat going on. They may be looking at a monitor to look at the documents, and another monitor to look at the transcript. So needs to be taken thinking about how can you best replicate an in-person experience, even though you're doing it virtually. Another issue that is very important is sequestering witnesses, because obviously if the witnesses were to come to the venue, then we know that both sides could have a sense of whether the witness is sitting in a room by themselves, whether they're being kept to themselves while their evidence is being given and is live. But when a witness is in a different jurisdiction, that's a big problem. Thinking about whether they're being coached, thinking about whether they're by themselves, whether they have notes. One very drastic approach we've seen in certain high-profile cases is for lawyers to travel to the remote location where the witness is and to sit in a room with them. But there are other ways that we can can satisfy ourselves that everything is above board with witnesses giving evidence by video conference or video link remotely. And that is asking the witness to testify at an empty desk so that the camera angle shows everything that is before the witness. Avoiding the use of these virtual backgrounds which blur the surroundings of the witness, so we can be sure that the witness is not being prompted and is not in any way being having their evidence tampered with. Having the witness speak directly to the camera, having 360-degree angles on the camera in the room. So there are various ways of doing this. Obviously, it depends on the scale of the case, your budget, but thinking proactively about the nitty-gritty is important, because it's much more difficult to turn up to a hearing, to start cross-examination, and then say, oh, I can't see the witness's hands. It's very difficult to address that issue in the moment. These are things that have to be done well in advance if you are to ensure that you can uphold these very important technical and procedural issues and ensure the integrity of the proceedings. Now to the next big issue. If you go to the next slide, Shreya. This is a big issue, internet connection. And this is as true for arbitrations, whether in any country, in the UK, in Europe, where people are giving evidence, all over the place. This is a big issue. It can be incredibly frustrating, and it can diminish the impact of the pleading, especially if it happens repeatedly. And it can reduce the credibility of your witness. So if I could tell you, again, last week, there were times when the internet connection seemed to go down at the most opportune moments for that witness. And the question that came to our minds immediately is this a genuine technical issue, or is this a manufactured technical issue? So all these things, again, go to the dynamic of the hearing and to the strength of your case. So you want to ensure that you can satisfy yourself that the internet connection is very good and it won't interfere with the way the witness gives evidence and the ability of the tribunal and yourself to assess that witness. And apart from those practical issues, there are due process concerns, big due process concerns and fairness concerns which arise on internet connectivity. Because if you are not able to present your case because of internet connectivity, or one party is less able to do so, then it will engage the New York Convention set aside ground that I spoke about at the beginning, and you may have issues at the end of the arbitration with one side saying, I wasn't able properly to put my case. So what are some of the solutions that we can think about in addressing this connectivity question? We need to agree, again, a protocol for the issue of technicality, technical issues and technical difficulties. What happens, for example, if the internet connection goes down? How long should the tribunal stop? What about inability to reconnect? What do you do? Do you go to another witness? Do you have some witnesses in person and some virtually to cut down on the risk? One thing we did in the hearing we're doing, we were concerned about witnesses and connectivity in Nigeria, because they were in various locations. We moved them all to Port Harcourt to one facility, even though the hearing was virtual. We moved them to one hotel where we could ensure and we were satisfied that the internet connection was stable. So even though it was virtual, we brought the witnesses together to a joint place where we could, both sides were satisfied that the internet connection was stable. So that could be one way of doing it. You can also organize a backup conference call line so that if the video goes down, you're still able to have the evidence being given orally by telephone if that is what's necessary to move the process along. But what is very important, and I can't stress this enough, is ensuring there's an open line of communication between you and the other side. This is not virtual hearings don't work if both sides don't work together for the mutual benefit of each other and pushing the arbitration forward. This is one thing that I've noticed. You have to work as a team to have a successful arbitration delivered. because one side can't be at loggerheads with the other, or else everything will fall apart. So now let's look at some other considerations that may arise. What happens if one party opposes a virtual hearing? And we've seen that in the pandemic. Certainly at the beginning of the pandemic, we would have a case that was scheduled for hearing. One side says, okay, we can't wait anymore. Clearly the pandemic isn't clearing up. Let's have a virtual hearing. And the other side saying, no, they don't want a virtual hearing. What is the position there? Do you have a right to a physical hearing? Can the tribunal overrule one party and agree with another party? What is very important is that to notice that the rules, there's no set rule on this. It turns on the law of the seat of the arbitration and what the rule is there. And the International Council on Commercial Arbitration did a study recently on right to physical hearing. If you Google it, you'll see it, where they studied the question about whether there's a right to a physical hearing in various jurisdictions. There is an entry in South Africa, an entry in Zimbabwe, and you have to really look at the law of the seat to see what the powers of the tribunal are and the rights of the parties are. Most arbitration statutes are silent on this issue, and so you have to figure out what the rule is in relation to this. But again, if the tribunal makes the wrong call, there could be serious due process issues which would really engage a challenge to the arbitration award. There are other issues such as time zone, and as I said, access and reliability of internet connection, security and confidentiality. These are some of the various issues which are implicated when you're thinking about virtual hearings. And here, we've provided a list of resources that have been developed by various arbitral institutions to deal with virtual hearings, draft protocols, checklists, to trigger your thinking about what you should be thinking about and how to organize virtual hearings. We found them immensely helpful, and it's a wonderful tool when you're approaching the other side. If you say to the other side, we're not imposing rules on you, we are imposing something that has been set down in the sole protocol. We invite the tribunal to adopt it and we invite you to accept it. That's much easier to start from a set template, and then you can amend it to fit the circumstances of your case rather than trying to invent the wheel from the ground up. So I think that covers most of what I wanted to say. But as I said, the most important thing is to be proactive.
Thanks, Conway. Just one question. I think you obviously mentioned a few times that proactivity is most important, and that means developing a hearing protocol, opening a line of communication with the other side. What other couple of top tips would you say a lawyer should practically do as part of his or her proactivity?
I think you've covered them. I think that, there are many issues there, but I think the communication on both sides is the most important thing, and being proactive is thinking through every step, which we're not very used to doing, because really going up to the hearing, we are trying to, make sure that our opening statements are on point and make sure cross-examination scripts are ready. But these really require a lot of thinking. I found actually virtual hearings much more stressful to set up than in-person hearings. So perhaps having one member of your team being responsible for the whole logistical dimensions of it, and thinking through every step of the way. Thinking about breaks. What happens when you have to take a break? Where does the witness go? I think that's really important. Proactivity and thinking through the process and communicating actively with co-counsel, the other side, and the tribunal.
Patrick, I see you've come off mute.
Yeah, just to say that I wanted to remind everyone that there is a Q&A function on the Zoom, and I think that brings us to the end of what we were planning on saying. And so if anyone has any questions that they would like to put it to us, you can write them into the Q&A box. I don't know, Michael or Brian, if there's also the possibility of unmuting themselves in order to ask a question.
And our contact details are on the screen. If you wanted to contact us, as Patrick said, there's lots of different issues, and we've only been able to touch on a few today. So we look forward to hearing from you.
I see there is a question, Shreya, now in the Q&A.
Yes, and the question is it possible to have an agreement of codes of conduct where divergent jurisdictions are involved to avoid complications? And I think, Patrick, that one might be for you.
So, yes, is the short answer. I mean, there have been various attempts by the IBA and other bodies to develop codes of conduct for arbitrators and for counsel. And you can simply agree with the other side that that code of conduct will be applicable. Now, when you're agreeing on something like the IBA rules on the taking of evidence, you need to be express.
I think we may have lost Patrick, maybe. Discussing internet connections, and there we go.
I was thinking the same thing.
While we're waiting for Patrick to rejoin, I think, Michael, a few people have asked for access to the slides as well as the recording. So I presume that we can send the slides over to you, and then that can be arranged to be sent over to the attendees.
Yes. You will find that the webinar is available on the AFSA website. And if you go to the website, you'll be able to go through it and hear it again. Sure.
Great, thank you. Conway, while we're waiting again for Patrick to join, there's one question which has come, which is slightly different, but maybe you can address it. Seems arbitration is dominated by older, accomplished counsel. How do we get young lawyers to get involved in arbitration?
Oh, wow. Okay, so I'm very, very passionate about this topic. I think that those older lawyers are actually the solution to the problem. I think that mentoring is very important, but I think what is most important is not just mentoring, but them giving individuals an opportunity. So, for example, what I've noticed about young people who've had their first appointments or their first foray into arbitration is a more senior person, when they've gotten an appointment or they've gotten a conference slot, to say, unfortunately, I can't take it, but I would highly recommend this junior person, and vouching for them. And that's usually the way that more junior people get on conference panels, get in front of the international arbitration community, and therefore build a profile so that they can either get appointments or build a profile to attract clients. It's also important in the context of running cases that senior lawyers give junior lawyers the opportunity to do advocacy, cross-examination, to build that skill so that people can see them doing it, so that they can develop those skills and in turn be seen as competent in the area. That's something I think that's happening a lot more. We saw recently, last week, it's happened not only in arbitration, it's also in court, where we saw the commercial court in London issue a guide where the judges have said, we don't want to see senior lawyers arguing only. You need to start mandating that junior lawyers do applications, because this is a real issue. It's understandable. Lots of the arbitrations are very high profile. They are lots of, the company cases. But I think we definitely need to have a partnership between more senior lawyers and more junior lawyers. And I think that's really the way that we get junior lawyers in front of clients, in front of tribunals, and help them develop a practice.
Thank you so much, Conway. Completely agree that mentorship is the most important part of this. I think we have Patrick back, and Patrick, we took a slight detour there, but maybe we can go back to finishing your answer to the question about differing ethical obligations.
Absolutely, and the importance of having a reliable internet connection. I have now got my telephone set up as a backup in case my internet kicks me off again. Yes, so you can sign up to those rules. I don't know if you heard me, I was just saying that it's important. They're often applied as guidelines. If you want them to be binding, it's important that you be really clear with your opposing side, that they will apply on a binding basis. And that will be different then to them just guiding the tribunal's approach to those things. But the other thing you can do is, if there's a specific rule that's or a specific issue that is of concern to you, simply request that the tribunal include it in procedural order number 1. They set out what the standard will be, binding both parties in relation to that issue.
Great. Thank you so much, Patrick. See, no more questions. So all that remains for us to do is thank the attendees today, and thank you so much to AFSA and to Michael for allowing us to present on this really important topic. It was a pleasure to be here today.
Well, Shreya, Patrick and Conway, thank you very much indeed. It's been a fascinating discussion, and we really have appreciated the benefit of hearing your views on these issues. Thank you so much. And as I say, it will be accessible, this webinar, on the AFSA website, and I'm sure that many people will visit it in order to get the benefit of what was discussed. Thank you so much.
Thank you, Michael. And we'd be happy to share our slides as well, and so they can go out to the participants. But thank you very much for allowing us to present today.
Great pleasure.